Hello, hello, hello. Welcome to our neck of the woods. This is the finale of the book Paper Arrows. I will be finished reading it today. And then after we are done with this, we are going to be taking a couple days off for the upcoming weather events and just to get some things done for ourselves around here. So, without further ado, I will go ahead and pick up reading where I left off. We were talking, the book was talking about um, mortgages and waivers of rights and how that is void on its face. So, that is just a refresher of where we were when we left off. And I'm just going to pick up right where we were, the end of page 57 of the PDF and the end of page 43 in the book. All right. And again, this book is called Paper Arrows Excerpts from Harold Griswold. All right. There was a case about what we just talked about called Wall versus King, 206 F 2D 878. This is a civil rights action for a fellow who got a ticket for driving under the influence of alcohol. They suspended his driver's license. He said that was a deprivation of his property rights under the color of law. He filed a civil rights case. He lost. We can find more in cases that people lost than in the winning cases. When the case is lost, the reason is given in many of them. And then we find out what not to do so that we do not commit the same mistakes and lose the same stupid way. The end result of this case was that the court said that he had signed an agreement to get a driver's license. If he signed the agreement, then he knowingly waived any right that he would have that they could deprive by taking away what he got by signing the agreement. Suspending his license was part of the agreement if he did not follow the rules. He had agreed by signature to follow the rules, so they had the right to take his license. He did not lose anything. If you have a driver's license, you do not have a right. You waived it. Did you know that you were prompted into a waiver of rights by getting a driver's license? Did they have a good faith obligation to tell you that you were prompted into a waiver of rights by getting a driver's license and that it was a privilege that they were extending you and that you were waiving all your natural rights by accepting the license? But they did not tell you that. In this case, they quote out of Civil Rights Key 1 from West Key Publications stating, action taken by state official in purported exercise of authority conferred by state is action under color of law. That means that any action at all taken by a state official under any state statute is an action done under color of law. This guy that we're talking about that filed the civil rights case, because they took his driver's license away as a result of being given a ticket for DUI, lost the case because he did not show any fraud. He did not bring up any counter of any kind against the original agreement. I think we could take the same basic pattern of this case, work the fraud of the roads into the pattern of the case, and come up with a winner. But I do not have a reason to do this. They have not bothered me. I do not have any tickets for driving without a license. I might get one soon. Any of you that do have a ticket ought to consider using Wall versus King as a guideline and Lynch versus Household Finance. The last time I was down here, I brought what the lawyer had drawn up as a complaint in Lynch versus Household Finance. The lawyer was a young man just out of law school who took a real interest in his work and did a terrific job of putting the case together. It was very successful in the Supreme Court with the decision that came down in favor of the rights of the little people like us and Mrs. Lynch. I think that it is worth following, and if you follow that kind of layout and work the details in accordance with the way that this Wall versus King case goes into the function of the claim of fraud from the very beginning by the conversion of the roads, I think that you would be putting together a very interesting case against the cop or the judge or anyone else, such as the town, being that is a town cop. By the way, if you sue the town or county, or if you sue the state, they are corporations. Corporations are artificial persons. They are fictions. They appear to be real persons, but they are not real at all. They have names and addresses just like other persons, but they are not human beings. Note, a human being does not have an address, but a corporation must have an address to exist. A human being may dwell or sojourn where he receives his mail, or he may choose not to be there at all, or he may choose to receive mail at many locations which may have been assigned an address by the USPS, which is separate from the post office. Since they are persons, they have a political or business capacity and a personal capacity. So a corporation can be sued in its personal capacity for the actions that it may have done. Then it has no immunities. The corporate veil of protection is blown completely away by suing it in its personal capacity. That is just like the government official's political immunity claims are blown completely away when you sue him in his personal capacity. So, if you go after the town because the town cop wrote you a ticket, and if you put the kind of case together that we just talked about, you go after them in their personal capacities and include the cop and the town. It would be nice to be able to shut down some of these town governments. That would shut down zoning laws and all this building permit nonsense, and would take an awful lot of pressure off the good American people. They would not have to pay so much. The state would not get the money that it needs to pay back the debt that it owes. The debt would finally get so high that the state government would have to close. When that happens, the U.S. government would have to close. When they close the doors, the people will be free again, not tied to this enslavement of the giant systems of government. Cases like these, filed all around the country, can help make these changes. They will be used like paper arrows to shoot into the courts to effect the fall, similar to the Roman Empire. Shoot your arrows straight at Babylon. Every time we hit the government with one of these cases, it is like hitting them with an arrow, and every one will wound them. There were mistakes made in another area years ago. The area was civil rights. We were led away from using civil rights legislation available to us. We were led away from not wanting to be part of a civil rights movement. We went to the police department and asked the police to bring charges of deprivation of rights under color of law under Title 18, Section 242 against another government official. They ignored us. So we went to the U.S. Attorney's Office and asked him. He ignored us. We never did figure out how to file a deprivation of rights under color of law, Title 18, Section 241 and 242 case. You cannot. You have no right to do so. You have no authority to act. USCS Title 18, Section 242 mentions a case of a defendant who filed suit from within a jail. He was a prisoner. It states, persons to institute prosecution. Prisoner could not properly personally institute criminal procedures against state and its officers for violation of his rights under the color of law. Any such complaint should have been sent to the U.S. Attorney General's office. This book did not say the U.S. AG, it said U.S. Attorney. I got the court case used as a reference, and it specifically said U.S. Attorney General. So there must be a difference between the U.S. Attorney and the U.S. AG. There is a big difference. The U.S. attorneys are the attorneys hired by and are on the retainer for the corporation known as the United States. The U.S. AG is completely different. The rules set up by Congress are completely different than for U.S. attorneys. There is a definite separation there. The U.S. AG will act in cases that the U.S. attorney will not even touch. There is a difference. You must send a complaint to the U.S. AG's office. The case also noted that the U.S. AG had the power to instigate an investigation of the complaint by the FBI. So the FBI will investigate your complaint of civil rights violations if it is filed with the U.S. AG's office. So if you have a civil rights complaint under Title 42, Section 1983 in the civil arena, and you want to press this party a little bit further, you file a separate request for a criminal complaint to the U.S. AG. These government officials are not anxious to be sued or to be charged with criminal offense. If you put enough pressure on like this by the beginning to file some of these types of suits in a case that is really pressing, they may well back off. They may also get a lot more nasty. If they do, you just write a second letter adding the nasty stuff that they have just done to you as an additional deprivation and try to force the issue for an investigation. If an investigation starts, that is when they will back off. We have gotten them in this position a couple of times, but we have not been successful yet in getting them to actually act. They come up with weak excuses as to why the officer acted that way, or say that it was only this one time. Not true. They take the side of the official or officer because of the lack of suits that come up like this. If there were more of these types of suits filed, they may have to take a more serious course of action against the government servants. More people need to file these types of complaints. Under this ridiculous set of civil rights statutes stemming from the 13th and 14th Amendments, particularly the 13th, putting you in jail because you did not pay a debt is called peonage. There is a whole series of statutes in Title 18 U.S.C. called the peonage laws. They start at Section 51. There are lists of cases from about 1880 to 1991 that show that any party who puts you in jail for a debt is liable to you. It also says that they are criminally liable if the government wishes to proceed against them criminally if they put you in jail for a debt. Pardon me. Give me one moment, folks. All right. Let me take this moment to take a break and say hello. Hey, Shift Kicker. Hey, Marco. Good to see you. The third person lurking. Good to see you too. All right. The Dave DeReimer story. Dave had a piece of rental property with a leak in the septic tank that was reported to the government by his tenant. The government came out, wrote a ticket to Dave. The ticket looked like a traffic ticket, but it was from the EPA. The ticket of $125 was for not getting a permit to let the septic tank leak on the lawn. Not because it leaked, but because he did not get a permit to let it leak. They did not sign the complaint. They just printed their names on it. The complaint has a space on it where the Justice of the Peace for Delaware courts is supposed to sign as a witness that the government agency signed the complaint. They did not sign it. They just printed their name, and it is doubtful whether they even went to the Justice of the Peace because he did not sign it either. The instrument is now lacking two of the requirements of the law. The government sent Dave notice of the complaint and a copy of it. So Dave sent a plumber and fixed the problem. No more leak. The government flunkies decided to pursue the collection of the $125 owed on the ticket and sent him a second notice that said that he had to be in court. But the letter went back to the court unopened and stamped return to sender. So Dave never got the notice that he was supposed to be in court. But because he never showed up in court, the two flunkies filled out an application for a capias, and the judge of the Common Pleas Court issued the capias. The capias is merely a warrant for arrest. It is an old common law approach to an arrest warrant. It was basically oriented around debt. In Delaware's law statutes, it says that capias will not be issued to any citizen or person in the state of Delaware unless first there are a praecipe, judgment, and affidavit in the court clerk's office stating that the debt is due and owing, and that the debtor is expected to abscond with anything of value or property that might be collectible. Dave owned several houses and was not any threat to flee over $125. They did not do the affidavit stating that the debt was due and owing. The law says that they will not issue the capias unless all three are on file. The affidavit has to be there, otherwise the capias will not be issued. The question arises as to why the judge would sign the capias if he knows the affidavit has to be there. This whole thing sounds as if there are several government officials bending the law here. They came out to Dave's house and wanted to execute the capias and arrest Dave. So they pulled out their guns, flashed them around in front of him, and threatened to arrest him. He shut the door and called the clerk of the court and asked her if she would fax him everything that was on file in the clerk's office. She agreed to do that immediately and with a friendly tone. She was a nice person, as most of them are. The affidavit was not in the file, so Dave advised them that they would be liable. They stated that they did not care. They would arrest him anyway. So Dave said that he was going to make them wait a little while for him to be arrested. The agents said that if he did not come with them immediately, they would call for help. They did just that, and SWAT teams came out. The regular state police showed up. The Lewes, Delaware police, came out, and the ferry police from the ferry boat landing. There were about 100 cops on Dave's front lawn waiting for Dave to come out. In the meantime, the news media reported that there was a hostage situation. Dave liked it because he was getting news coverage, and the standoff went on for about 6 hours. The media had made a mistake about the situation and apologized and said that the police had him held up in the house and there were no hostages. But maybe they were correct. Dave was being held hostage by the police on his front lawn. Dave called us and then called a good friend who was a lawyer, and the police let the lawyer in to talk with Dave. They always let a lawyer in, but would never let any of us in. Lawyers are allowed in to talk to Dave Korsak at Waco. The lawyer told him to let the police arrest him and that it sounded as though Dave had an interesting case, so he did that. The police took him down to the station and then took him to the local county jail. The people at the county jail told him that there was a regulation that he had to take a blood test before they could let him in with the rest of the prisoners. They said they needed to know whether or not he had AIDS. He refused to allow them to stick anything in his arm because he said they gave him AIDS if the needle was dirty. And now there was another standoff, and it went on for 5 weeks. Dave flatly refused to let them punch holes in his body and play around with his blood. So they put him in confinement away from the other prisoners. He had no telephone, no visitors, no mail, and no privileges. That was a mistake on our part. David put himself in a position that he could not get in touch with us, and we could not get in touch with him from outside. So we could not do any actions like the McLaughlin case that I talked about earlier because he refused to sign their documents. But we needed Dave's signature on the complaint, and we could not even ask him if he wanted to do the action and then instruct him how he should argue the case if he did get taken into court. With no communication, we could not do anything for Dave. We decided not to let this happen again. There is a way to prevent this from taking place. The U.S. District Court will provide a form upon request known as Instructions for Filing a Complaint by a Prisoner under the Civil Rights Act, Title 42 U.S.C., Section 1983. The instructions are on one page. There are about 3 pages to fill in the blanks. These actions are very simple to do, especially for a prisoner. You fill in the blanks, answer the questions, and lay out your claim. You then ask for your relief. It states, do not enclose a brief. They will search the law for you. That is wonderful. Keep in mind that this is for a prisoner. They search the law, and all that is needed for the prisoner is to sign at the bottom. But that was the problem here. We could not get in to Dave to sign the form. To prevent this in the future, we should all have one of these forms signed and ready to go in case any of us gets into the same predicament. It is placed where our family or friends can get a hold of it. Now, if anything like that happens, we can fill it out with help from others if necessary and file it since it is already signed by the one in jail. We have discussed that we would file a McLaughlin case and refuse to sign any of the documents put in front of us by the police at the time of arrest or anything being presented at the jail and demand a probable cause hearing. Then we would file the case because they did not give the probable cause hearing and we had not yet given consent by our signatures. So they would be holding us without probable cause. With all this time gone by in Dave's case, we decided he should go ahead and sign and file a counterclaim later because they did not have the affidavit from the Justice of the Peace that we had mentioned earlier. We also found out from a friendly judge that if the affidavit is missing, the state is liable and all parties involved are liable for civil and criminal action. Now it must be put into a counter complaint. The jailhouse folks broke down some, and we were able to get through to Dave, and we told him that we thought what we thought he ought to do. We told him to go ahead and sign. He did, reserving all rights, and we bailed him out. Signing grants them jurisdiction. There is no right to a counter complaint unless they do have jurisdiction. So, to give them jurisdiction, the prisoner must sign to give his consent so jurisdiction can be established in order to put in the counter complaint. This is touchy, but it will work. We laid the groundwork for the counter complaint by following the rules and filing the proper motions. We had a hearing Friday. I called my wife Friday night 2 days ago, and she talked to Dave. Dave told her that the court did what I said and that they would do. They denied the motion to dismiss. That was good. They were playing right into our hands. We'll get the judges and 3 courts involved. We will also get the state of Delaware, the 2 flunkies from the EPA, and 100 cops plus the warden at the jail. Dave will be busy for a long time working on lawsuits, maybe a year or more. All of this would not have been necessary if we'd already had the form with Dave's signature on it to file immediately when he was arrested. They claim they will respond to a prisoner in 3 days, which is much faster than anyone else. That does not mean that they will come down with a judgment. But if you were to ask for injunctive relief, and they will respond with temporary injunctive relief in 3 days. If you want to get out because they have not proven probable cause and you want injunctive relief to let you out, they will let you out provided that you agree that you will come back if they say that they are going to end the injunctive relief. They just might end the relief. You never know what these clowns will do. They all seem to act differently. I want to talk about property and what to do about getting back deeds and such, actually recovering the deed so that you end up with the allodial title. Section 3-305 of the UCC, the rights of a holder in due course, says that the holder takes the instrument free from any claims to it by any person. That means that all right to property is in the hands of the holder of the instrument, not the hands of the person named as the owner. You do not even have a right to claim anything on the property. The owner lost all of his right to the property. A deed is supposed to transfer title from one owner to another owner. Title is an imaginary thing. It is not real. It never has been real. It goes with the property. In the ancient days, they picked up a handful of dirt and handed it to you. That handful represented the whole piece of land that you were buying, and you were seized of the ownership of the property. People were so honest back then that you did not need to write up a document and file it in a government record. There was no thieving government to steal it. By the way, the way it works now is the thieving government actually steals the rights to the property away from you by getting you to file the deed in their records. In the old days, the title was allodial. The king destroyed that by making feudal title in England. The Roman Empire also destroyed it by feudal title. Feudal title meant limited title. At the pleasure of the king or of the Roman Empire, you were allowed to live on the property for a fixed period of time. The fixed period could vary from months to many years or even a lifetime. But at the end of that fixed time, the deed expressed that the property was to be used by you. The property reverted back to the king or the Roman Empire. They did not go quite that far in this country. There was, at least, a allodial title in this country. That is the reason that caused people to leave England and come here to America to own property and to have property rights. Allodial title meant that the piece of paper or whatever it was that identified the property was in your hands. No one else had any interest in the property in any way. They would have no interest in the rights, the use, or the time to be held by you. None of those things, and others not mentioned, were divided among 2 or more people. It was all actually seized in you, the one person. That was allodial title. Today, if the holder of the instrument acquires the right of holder in due course, there is a shared ownership of the property. So it is no longer allodial. It does not matter whether it is done with a deed or with a land patent or any other things that the people are finding to be filed in the records of the court. They are all still ways that produce an instrument, and there is still a holder in due course which has all the right in the property. There is no allodial title when the property is filed in public records of the court. If you want a allodial title, you must get the title and the deed and any and all papers referring to that property out of the hands of anyone else and into your hands only. There is a way to do this. We should look up everything we can on the word color as it appears or is related to color of law. In words and phrases from the shelf of the University of Maryland Law Library, color is defined very well. It also defines a colorable title. Colorable title, such as a title which gives the appearance that the title is in your hands, but it is not really there. It has the appearance of being the real thing, but it is not real at all. The deed that we have today, that is filed in their hands and in our hands, has the appearance that we have ownership to the property, but they have the rights. We do not have all of the ownership. It is colorable. All deeds and titles today are colorable. That's not just for land, people, that's for cars and everything else too. Colorable title, under which a good title may be acquired by adverse possession, means a writing which, on its face, purports to convey title to realty, but may not convey true title for want of title in grantor, or because of defective mode of conveyance. Now, they're grabbing a copy of the deed and putting it in their records, removing the right of property from you. It is a defect in the mode of conveyance. Along with the process of conveyance from me to you, when I sold my house to you and you bought it, an honest system would guarantee that everything that was there and all right, title, and interest to it conveyed to you when you paid me for it. So, if some dirty lawyer comes along and takes the deed over and files it in the public record, he thinks he has done what is required by law to do. The law states that it should be filed. It does not state that it must be filed. But the lawyer is a good government agent, and if it states that it should be filed, he will file it. He is looking for praise and a raise. He is trained to do what the government says. He is stealing the right of property from you and is not aware he is doing it. He is making the state an interested party in the property as holder in due course, and the state now has all the right to the property. All claims should be filed is expressed by the statutes because it is beneficial to the government if the claims are filed, but it does not say must. The government could not become holder in due course if the claims were not filed. That is why the statute states that it should be filed. It is in the government's interest to be filed in public records in court. Since the state has all the right to the property, that is how they have an interest in it, and that is a defect in the conveyance. A part of what was just bought was immediately lost. This is what happens the first time the property is bought. The next time the property is bought, it is automatic because of what the book stated in the sentence previously in the definition of color of title, which on its face purports to convey title to realty, but may not convey true title for want of title in grantor. Once this thing has been filed the first time and the right of title has been removed, it is sold to someone else. They do not get true title for want of the title not being in the seller's hands. It is in the hands of the state. Deeds are always held in the hands of the people before 1930. Now the deeds are filed in public record. There is no allodial title if it is filed in court. Now, no one has true title to pass it to the next buyer. It is being passed defectively due to the fact that it lacks the right of property, which is held by the state. I'm going to take a break there and get something to drink real quick. Give me a second, guys, and I will be right back. All right. We're almost done with this, guys. Bear with me. I really want to get through this and get this book finished up for y'all. All right. Now, I know this sounds like a lot of jargon, but if you go back and listen to the previous readings of the book, it's going to make a whole bunch more sense, and you're going to understand the deceptions that we've been suffering collectively as a country while we thought we had freedoms. Okay? So, all right. This makes the court the true banks in this country. Look up the definition of bank in a law dictionary. A bank is a court. It may be gotten back by adverse possession. There is a type of court case known as an adverse possession claim that may be filed. All that needs to be done is to explain how this fraud was perpetrated, who did it, and that the holder in due course now adversely holds the right to the property and that the true owner wants it back. There is also another way to get the deed back. The sheriff will go in and bring it out to you if it's done right. If the county holds your property and they put it up as collateral to borrow money, they are getting a benefit from it. The county never paid for the benefit. The purchaser paid for the property, paid the fee to the state so that they will accept the property and hold it for the purchaser. Then the purchaser pays rent to use the possession in a piece of property in which the state owns all of the right. The last two are known as filing fees and property taxes, respectively. The taxes, or rent, is paid over and over every year. It is paid just because it is filed. It is not an honest act to manipulate property from anyone. You have the right to do something about that act. You could send the government a bill for the full value of the property since they are holding your property. Let them know that you want them to pay you. Send them a notice and demand for payment. They will ignore it, and that is good. That's what you want. Send it by certified mail, process service, or courier. When you have proof that they have received it, you must give them about 30 days to respond to it. They must pay the bill or counterclaim that they do not owe the money and for a specific reason. If they fail to do either one of those two things just mentioned by the end of 30 days, plus 5 days to allow for mail, send a second notice and demand for payment. Get proof of their receiving it and give them 15 days to reply. After the 15 days, give them another 5 days for mail to be delivered. They must respond specifically, such as, you said that I owe you money for this reason. I do not owe you money for this reason because I do not have the deed in my hands. Just replying, I do not owe this, is not sufficient to answer a notice and demand for payment. They cannot answer that. They do not have the deed in their hands because they do. So they will not answer. Every time that they do not answer, you get to do the next step in the procedure. The next step in the procedure is to send them a notice of default with a copy of each of the first two notice and demand citations and proof of service for each. When they still ignore it, you must then go to the state court rule for your state. It will be called default. It is Rule 55 in the U.S. District Court Rules. Entry of the default is automatic by the court clerk. There is no need to go in front of a judge. All that is required is an affidavit that the first and last notices were sent and the final demand was sent. The proofs of services must be there too, and they're talking about your little green certified mail cards. Then you must write a request to the court that the court grant default judgment based on the affidavit. When these two steps are done, you go to court clerk's counter and you pay them. What you are doing is filing a complaint for default judgment. There is always a fee to be paid to the court when you file a complaint. The court clerk will then send you up to the judge, and the judge will wait 30 more days. A copy of all this must be sent again to the person who is in default, making them aware that it is now in the hands of the court. They must petition the court. If they fail to petition the court for a hearing within 30 days, the judge will tell the court clerk that it is all right to sign the default judgment, and the clerk will do so according to law. You still do not have much other than the decision. You must then file another complaint, which is called the request for a writ of execution. In some states, it may be a request for a writ of capias. The court clerk will provide the forms to petition the sheriff to execute this collection of the money or the property or whatever is named on the form. You will tell the sheriff to bring it back to you. He will follow the instructions. If you want the sheriff to go to the county's bank account and pay you the amount you ask for, he will do that. If you have to put an alternative to it, such as taking the deed to the property out of the court records and bringing it to you, he will do that if the first alternative is impossible. The deed must be taken out of the deed plat book and returned to you, along with the UCC-1 forms that are in the vault that the lawyer filed when you bought the property. They no longer have holder and due course rights in your real property. You own the land, have the title, and own all the property in the land. Guys, this is important stuff, okay? At the end of this, he gives you this information here. I think these are where all the forms start. So give me a second here. Yeah, I'm not going to read the forms to you guys. This is the form for notice and demand, right? And it's just a template for you to use. Oh, look at that. That's beautiful. And you would sign this with a beneficiary signature. Okay. This is beautiful. There is a notice of revocation of signature and power of attorney and consent. This is what you want to send in to all kinds of places. Anything you've signed that you want to revoke that signature on, that you want to get your rights back, and you want to say, you know what? I'm not doing your shit no more. This is what you want to start with. Notice of revocation of signature and power of attorney and consent. So you are revoking on all your licenses, on your marriage license, your birth certificate, any bonded action that they have done against you, any waiver of rights that they have done against you, even the bank, even when you went and set up your bank account. Okay. This is beautiful. So, and then down here is going to be, let's see here. This is case law. This is a civil action, notice of default. So this is your example. Again, the links to this book and all these forms are in the description box, okay? This book is called Paper Arrows. This is the PDF version of it. There is a link straight to the PDF version for you guys to get this, all right? Example questions and answers. If you guys really want to take your sovereignty back, if you really want to express and live with the liberties that you think you have, this is a good start. This is a very, very good start. Okay. I'm not going to read the rest of this because this is all the like appendix stuff, the forms, different lawyers that you can get in touch with, different things that are done. Look at this, titles of the United States Code. It's 76-page PDF. I highly, highly recommend printing this out and grabbing you a highlighter, making you lots of notes in the margins. Here is the creature of law versus creature of God. Really, you guys, we need to start understanding what they have done with our language and how they have perverted it so that we understand how to say, the Most High created me and gave me my freedoms and liberties. You have no say in it, right? There is a way for us to get out of this system. This whole entire book has been about that. And quite frankly, I think we should be about that. We all talk about, lots of people have done this deplorable. Lots of people. As a matter of fact, please go check out Christopher Hauser. That man is a true patriot. His YouTube link is down in the description box. He also has a Telegram channel. He is educating folks on how to take back your own power. Okay? Take back your power. You can do this. It is completely mind-blowing how screwed they have all of us, right? They've done this to every one of us for generations. Okay, did you know that the United States Corporation of America has been under martial rule since 1861? Right? I'm gonna say something now that y'all are not going to agree with, and you're not going to probably like. Some of you will. You know, Abraham Lincoln did not abolish slavery. Abraham Lincoln enabled slavery. He is the one that made all of us into corporations. Okay? Look it up. It's factual. It's in the law. Look up 13th, 14th, and 15th Amendments. Look what he did when the southern states said, no, we're not going to play this game. And they left Congress. They left Congress, and Abraham Lincoln declared war and put the entire country under martial rule. Under martial rule, he doesn't have to abide by anything. He was the one true total power, right? Because that's how our government branches are set up. You guys, there are so many more things that need to be understood by people, and we can take back our liberty. We can take back our sovereignty, right? There are ways to do it without paying out your yin yang. And what it is educate yourself. Educate yourself. If you go and open up the PDF, like I said, those forms are at the end of the book there. I'm not going to read all the forms to you guys. You can go check them out yourself. Check out Christopher Hauser. Watch his videos from the beginning all the way through. Okay, this man is a complete and total freedom fighter, and he is not scared to share the information with you. He is, and I will tell you this: he is not making empty promises when he says, "I am willing to help you, but I'm not willing to do it for you." Okay, we have emailed him several times, and he has gotten almost right back to us. Okay, so yeah, he's not going to charge you. He doesn't want your money. He doesn't need it, but he's going to tell you how to get a hold of your own money. And all he's doing is offering you advice, free advice, free advice. You want to be free? You want to have liberty? Go get it. You can get it. I'm gonna put the link to the StreamYard in here, and if any of you guys have questions about the stuff that we're working on and the stuff that we've been doing, come on up and ask. And yeah, this is vital stuff. You know, we talk about the fight for freedom, and we talk about boots on the ground, and all these people talk about going here and going there. Stop giving them your power. Take it back. That is how you stand up to them. You want to hit them where it hurts? Hit them in their pocketbooks. Hit them in their pocketbooks. I guarantee they're not going to like it, right? That's the other thing. If you want real freedom, you have to be strong enough to take it. And I don't mean physical strength. I mean mental and emotional strength and stability. You need to be able to stand on your own 2 feet and say, this is the hill. This hill right here is the one. So, the more we learn, the worse it gets. No, it's not getting worse. Actually, I see a beautiful, bright future ahead, and we're about to start doing some filings of our own, and we are going to be using some of the case law mentioned in this book and some other sources from that SPC University, right? Because a lot of that stuff, they've done the case law for you already, and you know, all you have to do is go reference it. All you got to do is go Google Black's Law Dictionary definition of, okay, or American Jurisprudence definition of. All you got to do is go right on Google, and it'll tell you. It's going to give you the information you want. All that information exists for free out there on the internet. You don't have to pay for it. And you can free yourself from this entrapment that they've got us in. All of it. It starts with that revocation of your signature. All right. That's where you're going to start. And then you're going to start taking back. And the last section of the book, hun, was about getting your allodial title back for your property, all your rights therein. So you're going to want to go over that. Okay. I really think it's just really valuable information. I think it's really important. Like I said, Jeff and I are going to take a couple days off. We have a lot of things to do. We've got a couple winter storms coming in that are going to just make it where I'm not even going to, we're not going to mess with trying to keep a signal through those storms. We're just not even going to try to. We're going to take a couple days because we are working simultaneously on this other stuff. I have been note-taking and we've been printing out. We're getting our ducks lined up, okay? And I'm going to tell you right now, there's a bright, beautiful future for all of us. All we have to do is take it, right? So check out Christopher Hauser YouTube channel. Check this man out. He is super intelligent, and he's already worked it. He's already done it, right? I'm only sharing information. We haven't actually done it yet. I don't have proofs to show you. This man does. This man, he does, right? He knows how to use his 1099A as self-insurance. He doesn't have a license. His trust account does. Okay? These are things. There are things that you need to... It's like learning a new language, only a little less difficult.
Don't just watch them once.
Okay.
Over and over.
So take the time, do the research. Anything you find, throw at us. He is not a lawyer. He is way better than a lawyer. Listen, you don't need a lawyer. Exactly. Deplorable. Lawyers are agents of the government. They are agents of a corporation. So they act in effect of the corporation. They're not acting, not once, as for you, a human being. And if you're still claiming to be a citizen or a resident of somewhere, you are not. No. You have God-given rights, and you are a sojourner on this earth. That means you can go where the heck you want to. You're free to do that. And the government didn't give you rights. Okay? Oh yeah, it's the whole system, the entire system, from the bottom to the top and back down again. Okay? Is corrupt. It's all corporation. Your name, all capital letters, is a trust, which makes it a corporation, which makes it a fiction, which makes anything that happens on that a fiction to you, a living human being. So this is about taking your power back. This is about being sovereign, not being part of their system anymore. So if you're not ready for that step, I understand, because it's going to take a strong spine and a will of stone or iron or whatever you want to, and a strong mental capacity to move forward. But you are not alone. There are people all over right now taking care of business. They are getting their sovereignty back, and they are unapologetic. And I, as well, am very unapologetic about it, because the real path to freedom is not fixing a system that was built to enslave us. It is breaking away from the system. So, y'all, yes, Deplorable. The book is online. The link to that PDF, honey, is down in the description box. It's called Paper Arrows, Excerpts by Harold Griswold. That's not a dumb question. You haven't been here for the whole first parts of the book, so I understand. Yes, the link to the PDF of the book that we just finished reading is in the description box. It is online. You can just go read it. You can save it right to your computer and read it offline. It is a very good read. I think you would be very enlightened to see it. I think we may do the Matrix and the U.S. Constitution as a study section maybe sometime in the near future. I don't know if I'll read it out loud to you guys, maybe just sections of it, because it is super valuable information as well. So, well, I will just say this wraps up foundations too, right? In the first part of foundations, we talked about your spiritual foundations. You know, what we're talking about here, guys, true freedom, true liberty is going to be all of it wrapped together. If you're still reaching outside of yourself to place blame on others for your feelings or for how you feel in accordance to something that happened, maybe take a look inside and find out why it triggered you in the first place. I mean, I still have to do that on a daily basis. We all should be doing that, right? Let's be whole again. Let's be whole again. But let's take back all of our freedom, all of our liberty. You know, so this is just the physical 3D plane of it. But I refuse. I now refuse to let any of them take anything else from me. They don't have the right, nor do they have the jurisdiction, and I won't do it. So, love and light. I hope y'all have a great day. Check out the links in the description. If you guys want to do this in a serious manner, check out Christopher Hauser. Okay? Go check him out. The man is super intelligent and he has been doing this. Okay? You got to be strong to do it, but you can do it. So, love and light, and we will see you when we see you, because we are going to take some days off. So, have a great one.